3 counts of pandering, felonies of the 4th degree in violation of ORC 2907.322. At the time of the plea, Judge, you ordered a pre-sentence investigation, a psychological evaluation, and those reports were completed and submitted for court review. The defendant is present today with counsel, Mr. Goldberg. We're here for purposes of sentence.
All right, before we get to the sentencing hearing, I'm going to read the explanation of duties to register as a sex offender or child victim offender. To Mr. McCartney and then Mr. Goldberg, I'll ask you to have your client sign that document indicating that I've read that and informed him of his obligations. The case is, court case number is 23 CR 053. Conviction under 2907.322A5. McCartney is the last name, Gregory first name, middle initial A. Expected residence address 4838 River Street, Willoughby, Ohio 44094. Paragraph 1, you've been convicted of or pleaded guilty to a sexually oriented offense and or a child victim offense as defined in 2950.01 of the revised code and RA2, Tier 2 sex offender / child victim offender registrar. Paragraph 2, you are required to register in person with the sheriff of the county in which you establish residency within 3 days of coming into that county or a temporary domicile for more than 3 days. You are also required to register in person with the sheriff of the county in which you establish a place of education immediately upon coming into that county. If you establish a place of education in another state but maintain a residence or temporary domicile here, you are also required to register in person with the sheriff or other appropriate official in that other state immediately upon coming into that state. You are also required to register in person with the sheriff of the county in which you establish a place of employment if you have been employed for more than 3 days or for an aggregate of 14 days in a calendar year. If you establish a place of employment in another state but maintain a residence or temporary domicile here, you are also required to register in person with the sheriff or other appropriate official in that other state if you have been employed for more than 3 days or for an aggregate of 14 days in a calendar year. Employment includes volunteer services. Paragraph 3, you are required to provide to the sheriff temporary lodging information including address and length of stay if your absence would be for 7 days or more. Paragraph 4, after the date of initial registration, you are required to periodically verify your residence address, place of employment, and or place of education in person at the county sheriff's office no earlier than 10 days prior to your verification date. Paragraph 5, if you change residence address, place of employment, and or place of education, you shall provide written notice of that change to the sheriff with whom you most recently registered and to the sheriff in the county in which you intend to reside or establish a place of employment and or place of education at least 20 days prior to any change and no later than 3 days after change of employment. If the residence address change is not to a fixed address, you shall include a detailed description of the place or places you intend to stay, and no later than the end of the first business day immediately following the day you obtain a fixed address, you must register with the sheriff that fixed address. Paragraph 6, you are advised, in accordance with federal law, you must report any international travel to your registering authority no less than 21 days prior to travel. Failure to do so may subject you to a criminal prosecution. Paragraph 7, you shall provide written notice within 3 days of any change in vehicle information, email addresses, internet identifiers, or telephone numbers registered to or used by you to the sheriff with whom you have most recently registered. Paragraph 8, depending on your designation, you are required to comply with all of the above described requirements for the following periods of time and frequency as a Tier 2 offender for a period of 25 years with in-person verification every 180 days. Paragraph 9, since your expected residence address as stated above is located in Lake County, you shall register in person no later than 3 days after release with the county sheriff's office located at 104 East Erie Street, Painesville, Ohio 44077. Paragraph 10, failure to register, failure to verify residence at specified times, or failure to provide a notice of a change in residence address or other required information as described above will result in a criminal prosecution. Paragraph 11 indicates that you, as the defendant, acknowledge the above requirements have been explained to you, and you must abide by all the provisions of the Ohio Revised Code, Chapter 2950. There's a place for your signature, Mr. Goldberg, if you would provide that to Mr. McCarthy, please. Just do it as a sex offender, what you have to do. So you need to sign there. And that's your address, correct? You sign there. Of course. No. It's official. It's vendor's signature right there.
Yeah, he signed a year one.
Okay. All right, Mr. Goldberg, are you ready to proceed with sentencing?
Yeah, Your Honor.
Go ahead.
Thank you, Your Honor. I've had a chance to review the court psychiatric clinic report and the PSI. I find they are accurate, with the exception of, in the final page of I believe it's the PSI, it mentions that Mr. McCartney was convicted of felony threes. He was actually convicted of, pled guilty to information on 3 felony 4s. But that's the only thing I saw that was inaccurate. I've also provided the court an independent psychiatric evaluation that did some in-depth testing with regards to Mr. McCartney and the things that the court may use in determining whether or not somebody's a threat to reoffend. So we would ask that the court impose a community control sanction. I understand that these are the kind of cases that the state would typically ask for a prison sentence, and that's understandable. I think that Mr. McCartney presents a little bit different than maybe the average offender. Mr. McCartney, 64 years old, has been employed in the same job for 28 years with Lincoln Electric. That employment remains available to him, and the sex offender status will not affect that employment if he's allowed to remain in the community. A search warrant was executed at his home. There was activity that was witnessed by the ICAC unit. They went and got a warrant. They executed the warrant at his home. And he fully cooperated. That's one of the things that stood out about this case was the ICAC officers came in and they asked, where do you keep your child pornography? And Mr. McCartney says, it's on that computer, it's on that disk, it's on that thumb drive. Pointed it all out to him, didn't hide from it, didn't deny it, and made it easy on them to collect what they needed. There was no evidence of any other crime when they were in his home or anything relating to sex offenses or child exploitation. There were these videos and photographs on his computer. Mr. McCartney became a widower in 2008. Doesn't have a lot of friends. Started using the internet, accessing non-illegal pornography, and went down the rabbit hole of the child pornography and did download these images, and he's extremely ashamed of it. He's extremely ashamed of allowing himself to be drawn in to that. And I think if he had someone to talk to, if he had a close friend to explain what was going on, maybe he would have been steered away from this. But at the time when he was caught, he was in pretty deep. There's no evidence that he ever acted out physically with anybody or harmed a child in any way, other than the extended way that one hurts a child when viewing that child being abused. And he understands that. And one of the first conversations we had was, you can't consider this a victimless crime. There's a victim. You're looking at the victim. Just because you don't know who that person is, or that victimization was pixelized and went over the internet, doesn't mean that you're not causing harm to this person. It's something that I think it was hard for him to understand, and I think that in going through not only the court process, the court psych clinic process, his private psych clinic process, he's come to have a lot more appreciation of the harmfulness of what he did. So, I point to the court psychiatric clinic that made a specific finding that there's no indication of a significant risk of a hands-on offense by Mr. McCartney, and that they don't find more than a low risk of recidivism. His private clinic had some misinformation at the beginning about what the case was, and that may have skewed the results, but they did do an ABLE assessment and another assessment of VRT, which is the visual measure of interest in various types of material, sexual material, and they found that there wasn't any significant interest in child sexual material based on that finding. And that's where they showed pictures, and they don't, obviously he doesn't know what the test is testing, and it measures how long he stays on each picture before moving to the next one. That's in the private report. We also did an ABLE assessment, and they found that there was a fairly low risk level according to the material or the findings at the end of the report. I think it was a 10%, their estimate was a 10% risk of recidivism after 5 years, fairly low. I think that we have a person here who, at his age and after going through this process and seeking out the treatment and the assessments that he has, is going to be a low risk of reoffending, especially if he continues to assess those resources. I know that there's things that weigh against him here. There were a number of images and videos on his computers, and I think that is probably the major thing that's going to weigh against him from the facts of the case. But at the same time, he did cooperate. He gave everything up. He didn't try to hide what he did. I don't think there's any other evidence that he ever shared anything. He downloaded it and made copies. Some of these images are copies out of the many images that are detailed in the ICAC report. He didn't share it with anybody, and he didn't further disseminate this material other than to himself. Your Honor, if this is a felony 4, I don't think there's a presumption of probation. I think it's a neutral presumption because it's a sex offense. And I would say that if you look at the more serious factors, you can say that the age of the victim, the injury was exacerbated by the victim's physical and mental condition or age. Now, we know that the children in these videos and pictures were victimized. Were they directly Mr. McCartney's victim? I would say they weren't, but they were certainly victims, and I'm not sure that factor would really apply to Mr. McCartney, that his viewing of a video that may have been viewed by 1 million people was incrementally made the injury to the victim worse. Any viewing of the video makes injury to the victim, I guess, more severe, but it's really hard to apply that factor to him. Other than that, none of the other factors apply. I don't think any of the less serious factors apply, other than, the kind of catch-all where he started off looking at what was legal and was drawn into the illegal, as the people that publish illegal child pornography want to do. They want to get people that are looking at legal pornography and draw them into their world. And Mr. McCartney fell for that. As to the recidivism factors, he's 64 years old. I think he had a DUI. He's never had anything else or come in serious contact with the criminal justice system. And I do think he has substantial and serious and genuine remorse for what he's done here. Your Honor, he's had enough time to think about it and enough time to realize the harm that he caused to himself and then to the people who are depicted in these videos. And I think that his remorse is genuine, and it's not just the remorse one feels because they're afraid of going to prison. It's the remorse he feels because of the shame that he's caused himself and his family. So, I mean, I do think that the less likely recidivism factors do apply, and the more likely do not. So, with that in mind, Your Honor, I think that the court can fashion a community control sanction that doesn't include a prison sentence. And I understand that there's a local incarceration element that's available here that may be appropriate and would be adequate to punish him without using resources that were not necessary to effective punishment. You know, I hesitate to get into it, but 64-year-old, what would be classified by the average person as a child sex offender going into the Ohio prison system, maybe more punishment than is required in these particular circumstances. I know that if he were permitted to stay in the community, to go to work, he would continue with sex offender treatment and to do whatever he could to assure everybody, including monitoring his internet and anything else that would be required, or getting rid of his internet altogether, to assure everybody that county prosecutor, probation, this court, that there's no other offenses in him, and he's not going to be doing this again. Thank you.
Thank you. Mr. McCartney, what would you like to tell me before I impose sentence in this case?
I am definitely very, very remorseful about this whole thing, and critically sorry for whatever harm I did to anybody, unbeknownst to myself, that viewing these pictures and videos on the internet would actually be considered affecting somebody. But I positively, no way in the world would I even stand to harm anyone individually. I'm so sorry for the actions that I've done, and definitely will not ever repeat them again. And getting rid of my computer and stuff like that, to me, that's great. Just as long as I have access to be able to pay my bills and to, get my emails, I'm happy. But as far as, limiting my access on the internet, that's great. In fact, I think that'd be the best thing for me too. And I'm looking forward to going through these therapy classes too, just to give everybody else assurance that I am very, very serious about what I'm trying to do. And, I don't know what else to say really, except I'm critically sorry for this, and that we positive. No way would I even fathom to be able to do this again. There's no way. And I just have a total remorse for this whole thing. Thank you, Your Honor.
Mr. Rhoda?
Judge, as the state discussed in chambers with both the court and defense counsel, the state is asking the court to impose a prison sentence. The state is making that request based on evaluation of three areas, Judge. The victimization that took place in this case, the nature of the evidence, and the evaluation of the defendant. With respect to the victimization, I won't repeat what Mr. Goldberg said. but just simply say that these victims, yes, they are victimized over and over again, thousands of times when people view the images after they've been victimized on a hands-on basis as a child. So the victimization is very serious, and then defendants, such as Mr. McCarthy, perpetuate that. The evidence in this case, Judge, is significant. There was a large volume of material, both child abuse material and child exploitation material, and it appears that it went on for a significant time. It wasn't a matter of 6 images. There was thousands of images, and it escalated over time. And when you review Dr. Rinsberg's report, you see that he notes that there are pedophilic tendencies or disorder noted in his report. So for those reasons, the state feels that a prison sentence is appropriate in this manner.
Thank you.
And we'd also ask for the forfeiture of the electronics, Judge.
All right, I've reviewed the pre-sentence report. I reviewed Dr. Rinsberg's report. And I've reviewed the report given to me by Mr. Goldberg, Advanced Psychotherapy Services. I reviewed that this morning before I came in here. With regard to the offense itself, the execution of search warrant noted 20,392 items that were found, including images and video and other written stories. And it's shocking to me that people view these images of child pornography, in this case, some as young as, I think, my recollection, 5 years old up to, well, actually, they were 5 years old and up. It wasn't a situation where it was, looking at Rinsberg's report, it's not like you were involved with drugs or alcohol and then that's when you got on the computer. You got on the computer without that. And you noted the pedophilic tendencies in his report. There are some good and there's some bad in the advanced psychotherapy report, but the fact is, in these types of cases, and in this case in particular, there is an industry of child pornography that exists because there's a market for people to view child pornography. And as long as there's a market for people to view child pornography, there's going to be a system that exploits these prepubescent children. Not only just pictures, but videos where they're engaging in activity. And, so Mr. Goldberg is correct. It certainly is not victimless in any degree. Now, you may have not intended, or you may not have thought you were causing any harm to the children that you were viewing, engaging in certain acts or posing for certain pictures, but the fact is that they are abused, and they are abused over and over again. And this is not a unique case. This is a fairly common case. It seems to be more and more common. And in the context of these cases, there are victim impact statements such as they are. It's not a traditional, as Mr. Goldberg pointed out, it's not a traditional victim in the sense that it was one person that you knew and that was exploited. These are tens of thousands of children that were exploited. And I've read victim impact statements from those produced of the children that were in those things, and the harm is serious beyond your comprehension, I believe. So you have contributed in your own way to their victimization. And it's, I think it's an understatement that this is very serious activity that needs to be treated seriously. I recognize that you've not been in trouble in your life. Mr. Goldberg has pointed out that you've worked at Lincoln Electric for 28 years. This is your first offense, and it's a lot, because this is deadly serious by its nature and by its effect on the children that you view. And one of the saddest things is that these depictions will never disappear. They're always going to be out there. And so the children you viewed are going to be viewed again and again and again forever. And as I said earlier, the fact is that your actions have contributed, sadly to say, in a small way to where we're at in this industry, but in the same sense, in a large way, because if guys like you weren't looking at these images, then this industry would not exist. I have also I've considered all provisions in 292911, 292912, and 292913, and as Mr. Goldberg pointed out, in the normal F4 and F5, there's not a presumption of community control, and I'm going to find that you are not amenable to community control. On count 1, I'm going to sentence you to 12 months in prison. On count 2, 12 months in prison. Count 3, 12 months in prison. Now, this activity by the investigation revealed that it took place somewhere in the neighborhood of 95 to 100 days. That was the time frame in which we're talking about here. So I'm going to run those sentences concurrent to one another. When you get out, you're going to be on post-release control for 5 years under the parole authority with conditions. The parole authority, if you violate these conditions, the parole authority could return you to prison for up to 9 months for each violation, up to 1/2 of my sentence. If the violation of post-release control is a new felony, then you could get an additional consecutive prison sentence for the violation, the maximum of which would be the greater of 12 months or the time you have left under your post-release control. The items subject to forfeiture are forfeited to the state, and the costs are assessed. Is there any further, Ms. Naroda?
Nothing for the state, Judge.
Mr. Goldberg?
We are.
All right, we're adjourned.
All right.